Stephen, the floor is yours.
Thank you very much, Senator Flexer, and good morning to you and to Ranking Member Master Francesco and all members of the committee. My name is Stephen Lance, and I'm from the NAACP Legal Defense Fund. I'm testifying, like Lucas, in support of SB 1226. This bill will address critical local needs in Connecticut and make this state a national leader on voting rights. We at the LDF have worked for 83 years to fulfill the Constitution's promise of equal citizenship for Black voters and all Americans. A key tool in this work has been the Federal Voting Rights Act of 1965. But this crown jewel of the civil rights movement, which at one point was perhaps the most successful civil rights law ever, has been chipped away at by the Supreme Court in recent years. And today, its protections are sorely needed. This makes a bill like SB 1226 even more critical. This bill builds on the federal VRA and on state VRAs in New York, California, and other states. And one major component that SB 1226 adapts from both the New York and federal models is called preclearance. This is in Section 5 of the bill. Now, preclearance is a little bit of a technical term, so that's what I'm going to focus on today in my testimony. And preclearance is a review process, essentially, that gives a second set of eyes on certain changes to how elections are run. It applies in places with indicia of prior discrimination, and it stops harmful changes before they take effect. So preclearance was the heart of the federal VRA. For decades, it prevented the need for case-by-case litigation. That saved voters time and pain, and it saved taxpayers money. And several states covered by preclearance, including Mississippi, agreed and said to the Supreme Court that preclearance works because it's efficient, it catches mistakes, it promotes transparency, and it improves election administration. Research shows additional benefits. For example, in counties covered by preclearance, the racial wage gap narrowed as Black workers started getting paid more fairly. And SB 1226 brings this proven tool here to Connecticut. The bill lays out a framework that the Secretary of the State will apply to determine which places are covered. The framework looks at recent voting rights or civil rights violations, current indicators of potential problems, including racial disparities in turnout and racial disparities in arrests. And so during the period that a municipality is covered, the Secretary will take an advanced look at things like polling locations, redistricting maps, and list maintenance practices before they're implemented, just to make sure they won't have discriminatory effects. So this is an efficient way to identify and solve problems before anybody gets disenfranchised. Because when it comes to the right to vote, that old saying holds true, that an ounce of prevention is worth a pound of cure. So that's the principle behind preclearance. One of the key parts of the bill. It's one reason among many that I hope everyone in this committee will support SB 1226. Thank you very much.
That right on time. Thank you. Thank you very much for your time and your testimony this morning and this afternoon. Are there any questions or comments from members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Thank you for your testimony. I appreciate you coming in today. Can you, I'm really not understanding preclearance.
Okay.
Can you give me an example?
Yes. So, okay, let's say that that a covered town is designing its polling places for an upcoming election. And the person designing where those polling places are going to be, for whatever reason, puts all of the polling places on one side of town. Now, imagine that that side of town happens to be a predominantly white neighborhood, and the other side of town is a predominantly Black neighborhood. So if this town is covered by preclearance, the clerk will send that specific policy, that proposed polling place plan, to the Secretary of the State. And they also have the option to go to a court, by the way, for preclearance if they prefer, but they'll send that proposed policy, specifically that map of where they're going to put the polling places for preclearance. And then it'll get that expert set of eyes looking at it and saying, wait a minute, I think you might have goofed here. This plan appears to kind of have discriminatory effects in that it doesn't provide equal access to the polling locations for people of color as it does for the white voters on this side of town. So that's likely a situation where preclearance would be really valuable, and it would lead to a resolution without having to actually run the election and have people be disenfranchised, and also without having to have litigation, which can be very costly for municipalities and voters.
So do you see any of that in Connecticut right now, currently, that there's People that are disenfranchised because of where the polling location is?
Well, I hear what you're saying. So I think it's important to say this is a perspective bill, right? It's looking at potential problems that could arise and basically just putting in a problem solving framework so that when if that does happen, it will get resolved. There have been situations in the past in Connecticut in several recent elections where there's been particularly long lines in Black and Latino neighborhoods. I think in 2010, 2016, 2018, and 2020, it was pretty, statewide news. So now I'm not saying that those necessarily would have been situations that this would apply to, but I think it's certainly possible. That's one of the benefits of preclearance is they can look at those decisions, just like the states like Mississippi and the others said back in 2013, that gives you a second chance if you happen to make a mistake or something in the way that you've designed your election policy isn't going to produce fairness. You get kind of that second check, and you can solve those problems before somebody gets hurt.
Right. It just seems like in that particular example that you gave me, it's trying to find a problem that we don't really have here in Connecticut. I have not heard of anything like that. What else would pre-clearance do?
Well,
It gives the authority, I'm assuming, to the Secretary of State, right? So a town would no longer have the authority to determine where their polling, let's say in your example, where their polling locations would be, correct? That authority would have to go to the Secretary of State.
Well, I think there's a couple parts of your question. I want to make sure we cover them all. So you asked about other examples. You asked about the authority to determine where the polling places are. Now, it's very important that the authority remains with the local folks. It's just that the Secretary of the State or a court is going to check it to make sure it's not discriminatory. The Secretary of the State doesn't say, I decide where everyone's things go. It's just that the authority will be at the local level, but they'll have a second set of eyes to make sure it's not discriminatory.
Right. And in your analogy, you are assuming, based on everything that you're saying, that there's discriminatory practices in maybe, let's say, our polling places in maybe Black and brown communities, that they are being disenfranchised as opposed to the other people, as opposed to, let's say, white people.
Well,
is that the whole notion of your pre-clearance?
Respectfully, Representative Master Francesco, I think the answer is no. That's not the whole notion. Part of the thing to remember here is that this is perspective. It's kind of like buying an insurance policy. You don't wait until the tree falls on your house to start calling insurance agents, right? You put this framework in place so that should something like this happen, which we can all agree would be a quite serious problem, there's an efficient, streamlined way for it to get resolved.
Okay. Can you give me a different example? Pre-clearance. Okay, so you talked about polling locations. What else would it do?
Well, thank you. Actually, I can give you a couple of examples that might kind of illustrate things that have been found in violation in Connecticut in the past. So in the 1990s in Hartford, there was a voter purge process that was found to flag for removal Latino voters at a rate twice as high as other voters. So preclearance, of course, wasn't in place at that time. But if something like that were to happen in the future, if a local jurisdiction were to say, here's my plan for list maintenance just to make sure that I'm removing people who have moved away, and that also in the Hartford case, the people removed hadn't moved away. So it's flawed in a couple of ways. But if somebody were to propose at the local level a purge practice like that was going to wrongfully purge twice as many Latino voters as others, that's a kind of thing that preclearance could also catch. So that's one example. Another one I'd go back to is the case of Bridgeport Coalition for Fair Representation versus City of Bridgeport. This is a case, I believe it was filed in 1993. It ultimately was settled favorably for the plaintiffs in 1995. So this is a redistricting case, a case for involving local city council redistricting. And during the process of developing this local plan, a coalition of Black and Latino voters hired an expert map maker. They proposed to the city a plan that would have provided fair representation to Black voters and to Latino voters, a total of 5 districts of the 10 total, in which Black and Latino voters could have had an opportunity to elect candidates of their choice. But the city ignored that plan. Instead, they implemented they implemented a plan that had only 4 districts in which Black and Latino voters could elect candidates of their choice. And this led to litigation. The plaintiffs, the coalition, sued under Section 2 of the Voting Rights Act, one at the district court level, one at the Second Circuit. Ultimately, the Supreme Court issued another case clarifying a different aspect of Section 2 law while the case was pending. So the United States Supreme Court sent it back down to the district court to keep looking at it in light of that recent case. but the facts remained that the dilutive plan had been enacted. So after all that, the city settled and provided exactly the remedy, the plan with 5 districts that were opportunity to elect districts for voters of color that the plaintiffs had sought. But this took 2 years of litigation, and it cost a lot of money, a lot of time, and a lot of pain. An election took place during the pendency of this litigation. At the end of the case, exactly the remedy the plaintiffs had said federal law required was implemented. And the city had to pay the attorney's fees for the plaintiffs. So that's a 2-year process that could have been prevented by preclearance, because it would have caught that problem before any of this harm had happened.
So in that particular case, through you, Madam Chair, I apologize. You want to put candidates up in a specific district based on race? Is that what you're saying? Because it wasn't equal?
Oh, I think there's an important clarification here, Representative Master Francesco. What matters is not the race of the candidate that wins. What matters is the opportunity, the equal opportunity for voters of different races to have the opportunity to elect candidates of their choice. So in this case, what mattered was that the Black and Latino voters in Bridgeport, under this case, were arguing that they had been denied an equal opportunity to get to have a voice in our democracy, to get to say who represents them. So it's really about the right of the. I hope that was clear. If not, what matters is the right of the voters to choose who represents them.
Right. And I understand that. It just seems, and I remember this conversation we had last year, to some respect, that we're picking, the voters have a right to choose who they want. And a candidate has a right to get on the ballot as long as they go through the process, right? And the voters decide based on who they like best.
Right.
But what you're saying is that this process, it would somewhat change that. Is that correct? If I'm understanding it? It's very confusing what you're saying. I have to be honest with you. We keep putting race into this equation here.
Right.
And I'm not understanding it. So the voters put up a candidate. I mean, the town committee, whatever, puts up a candidate, and if somebody else is not that chosen, they have the right through a process to get on the ballot. They get their message out there, and the voters vote for them. And they determine if they like that candidate or not. I'm not understanding what you're trying to say here, how that is wrong.
Well, respectfully, again, nothing that you said just now is wrong, and nothing in this bill would change that process of voters choosing who they vote for. I think what this bill gets at here is situations where either perhaps a practice, a policy, or something like a redistricting plan, or in certain cases, the use of an at-large method of election denies an equal opportunity for the people to have a say in who gets elected. You know, you represent.
Yeah, I think
we can meet afterwards. I'd be really happy to talk through about.
I don't want to get into a debate with you about it. I'm just trying to understand where you're coming from, and in my opinion, I think people do have equal access to, and they have the choice of their candidates. I guess I don't know. I guess that's all the questions I have, but I appreciate you coming out to testify and trying to clarify some of those things. It just seems to me that we're trying to create a problem that we don't have, because I haven't heard any of these problems in Connecticut at all. And that was my concern. Thank you very much. Thank you, Madam Chair. I appreciate the time.
Thank you, Representative. Are there other questions or comments from members of the committee? Representative Haddad.
Thank you. And thank you very much for your testimony. I represent an unusual community. I have a small rural community, and in the middle of it sits the University of Connecticut. And so we have a very large urban like campus in the middle of our rural community. And as a result, we have a very high concentration of 18 to 22-year-olds that sort of dominates the regular or standard, typical voter in our community. Is age a protected class?
Age is a protected class under the 26th Amendment, which granted people between the ages of 18 and 21 the right to vote. This bill directly references the Voting Rights Act's definition of a protected class, which is race, color, or language minority group. So in this bill is written, age would not be a protected class, but in this situation, in some college campuses that are in rural areas, you may find that the college population is more diverse than the surrounding area. And in that case, a claim under the Voting Rights Act or a bill like this that included race as the point of discrimination would very potentially be relevant.
I appreciate that response because I think if you look at the demographics in our community, you would in fact see that the racial makeup of students on campus is much more diverse than what you see in the regular community or the rest of our community. And I just wanted, I've heard this, the questioning with Representative Master Francesco, and I'm not particularly proud to share the anecdote that I'm about to share with you. But I will share with you that in the 2008 election in Mansfield, we have a single voting place for students who vote on campus, and it's shared with votes who have some off-campus voting addresses. And I think, the 2008 election was unusual in that there was a very high level of interest from students who voted on campus. And as a consequence, the typical setup that was established at that voting site that day led to some serious inequities in terms of the way that folks could access their right to vote. So if you were a local voter with an off-campus voting address, you were directed towards one of two tables divided by your street name, as you typically find in many voting places. Students who had an on-campus voting place were directed towards the third voting table. At midday or somewhere around 2 o'clock, you could walk up to either the two neighborhood voting tables and vote in probably it took you 15 minutes. The line for students stretched around the building and was several hours long. And so I guess I wonder if that's the kind of procedure that I'm going to say, like, I think the moderator and the folks who said with the polling place were acting based on historical expectations and didn't react early enough to what was clearly an unusual election. But is that the kind of disparity that might be called into question in the way that you're referring to?
Well, I think potentially, yes. Like that's the kind of thing that that advanced review that pre-clearance can provide becomes really helpful for, because it's not the case that the people designing the polling place were trying to do something wrong, that maybe there's some factor they didn't consider. And when you send a pre-clearance submission to voting experts, in this case, in the Secretary of the State's office, you'll get basically their free consulting services. So that kind of thing that can cause a problem could be prevented from doing so.
Yeah, I appreciate that day. There was great resistance to modifying the plan by the moderator that was assigned to that voting place. But eventually, with some intervention, things got better and that line got moving much more quickly. And I'm grateful for that. In subsequent elections, I think our town responded appropriately and sort of staffed up those tables. And so we don't see that problem anymore. But I suppose had we not made those changes, then that would be the kind of systematic barrier that might come into play. Would it also, the Voting Rights Act also apply to Election Day registration?
Well, I think it's Section 2 of the Voting Rights Act applies to any relevant policy, practice, prerequisite to voting. And so I think that this also would potentially apply if there were disparities in access to the Election Day registration process.
Right. And so you've probably heard anecdotes about when Election Day registration was first enacted, that in several communities around the state, and again, mine included, there were lines out the door for Election Day registration. And in fact, many of those voters were dissuaded from joining that line with signs that said, the line is too long, you're never going to get through it. Is that the kind of discouragement and systematic process that might come under greater scrutiny with the legislature in front of us?
Yes, Representative Haddad, it definitely is. And that kind of barrier, that kind of thing that makes it harder to go in and exercise your vote, because people don't have all day to go wait in lines. And you see that many times people put everything else on hold, they'll wait in those lines. But even then, even if they're able to cast their ballot in the end, their rights, I would argue, have still been violated by requiring them to put up with that extra hurdle. The Fifth Circuit Court of Appeals, which is, based in Texas, put this very well. They said that in previous times, some people paid the poll tax and still voted, but their rights were still infringed because they had to put up with that extra hurdle. So I think it's important. Yes.
Thank you for your answers. And I just wanted to give some real life examples
Thank
of,
you.
when well-intentioned people can set up procedures that simply don't work on election day. And that turns into and can turn into a very serious problem. And then the denial of people's right to vote in a prompt and efficient way. Thank you very much. I appreciate it.
Thank you, Representative. Representative Blumenthal.
Thank you, Madam Chair, and thanks for being with us today, Stephen. I was wondering if you could describe for us in plain language the concept of racially polarized voting and how it's implicated in this bill.
Thank you. That's a great question. Racially polarized voting is another one of those technical terms that not people don't use it every day. But basically what it means is that there's a divergence in the candidate preference or electoral choice of people of color as compared to white voters. And it's really an empirical question. It's something that experts with PhDs study and determine whether it's present or not in a jurisdiction. And one of the reasons that it's really important to consider in voting rights bills is because under certain conditions, if racially polarized voting is present, it can contribute to a real unfairness. For example, I'll give you kind of maybe a little bit of an extreme example, but imagine a hypothetical town that had 10 seats for town council. And this town has a population of 51% white voters and 49% black voters. And now let's assume that racially polarized voting is quite significant there, meaning that the divergence between candidate preferences is almost 100%. So in that situation, if the seats are elected at large, all 10 of those seats could potentially be chosen by the 51% of the white voters rather than the whole nearly half of the rest of the town. So racially polarized voting, especially in what's known as the vote dilution context, whether with unfair district maps or in certain cases with the use of at-large systems, which again aren't always bad, but in certain situations can reduce these kinds of unfairness. Racially polarized voting is a key part of evaluating whether that creates an unfairness.
Thank you. And how is it determined whether racially polarized voting exists? You mentioned experts. What do the experts do?
Well, yeah, I should preface that I'm not qualified to do this analysis myself, but so, places like LDF, we hire expert witnesses who make a career of studying this. It's something that political scientists, have been doing for decades, and courts, including the Supreme Court, have recognized as valid and important. There's a Supreme Court case going back to at least 1986, recognizing the importance and the validity of this analysis. But essentially what they do is they look at the smallest geographical unit for which election results can be isolated, and they compare that to the racial demographics of that same unit. And that's a gross oversimplification. It's there's a lot of it's a technique that one of the best techniques is called ecological inference. It's a complex and sophisticated statistical technique that people, again, usually with PhDs will perform, but they can find with a high degree of accuracy the extent to whether voting is polarized along racial lines in a certain election. And the more elections they look at, it's the better the data gets.
Would it be fair to say that basically what you're describing is, and it's, I'm sure, an even more gross simplification than what you described. It'd be fair to say that these are essentially statistical experts that look at precinct data and compare the demographics of those precincts with their choices in terms of who got what votes in those precincts, because obviously we can't know what any in particular individual did in their vote.
I think that's a very fair characterization, and that's important. Yeah, it's not. They look at the election results would show whether a person voted, not how a person voted. But then they look at how the votes were cast in that precinct or that locality.
And so I guess if there's a high correlation between, I guess, the demographics of a particular district and their choice of candidate, that would be essentially an indicator of racially polarized voting.
That's my understanding, and we should caveat that the expert witnesses I've worked with may be watching and saying you're getting, but this is essentially, this for in layman's terms, this is essentially the concept. Yes.
Okay, and so what would this bill do where there's racially polarized voting?
Well, it would do two things. One, as in federal law under Section 2, in that same 1986 Supreme Court case I mentioned, the United States Supreme Court laid out a list of factors known as the totality of the circumstances that together give you a sense of whether the political process is equally open in a jurisdiction. And one of those is, and importantly, is the presence of racially polarized voting, because it interacts with the laws, the policies, the practices in that jurisdiction to help you determine whether there's a fairness. I won't go through the whole list of the totality of the circumstances, but they also include things like socioeconomic disparities and health and education, vehicle access, these kind of things that might impact your ability to get to the polling places. And so one thing, just like in federal law, if a person is filing a case against an unfair districting plan, racially polarized voting is one of the key factors that the court will consider in reaching that analysis of whether, under the totality of circumstances, the political process is equally open. Now, one innovation that this bill makes, which is actually an innovation in the sense that it's not in federal law, but it goes back to 2002 in the California Voting Rights Act, is a more efficient way to challenge at-large elections when there is an unfairness being produced. And so actually, we can go back to my somewhat extreme example of a town with 10 at-large seats and stark racially polarized voting, and a bare majority of white voters whose candidate preferences or electoral choices differ significantly from the Black voters. They have the opportunity to unfairly kind of determine every single seat on that 10-person body, right? So this bill provides a streamlined cause of action against at-large districts, where if racially polarized voting is present, that can be the key finding to determine a finding of vote dilution.
Thank you very much for that answer. And I have one last question. It seems like as we run through this bill, there's kind of two themes here. One is protections of the individual's right to vote, and also protections against the dilution of minority constituencies' votes collectively. Would that be fair to say? And would you point to any other themes beyond that one?
Well, I think
those two.
Thank you very much for the question. I think those are key points, especially with respect to Section 2 of the bill, which is the affirmative causes of action. I think maybe a couple of points that I might point out to, and which I think you'll hear testimony about today. In Section 4 of the bill, language assistance is provided on an expanded basis as compared to what's currently required under federal law. I won't go into the whole details, but it's a very good improvement. It makes it so that more languages can be covered than just the somewhat limited number of languages that are covered under federal law, and that this assistance can be provided in more places where there's evidence of a need. I'd also point to Section 6 of the bill, which includes protections against voter intimidation, obstruction, and deception. This is building on what's already in federal law in Section 11B of the Voting Rights Act, a statute dating back to the Reconstruction period known as the KKK Act, and others. Basically, this gives people an affirmative cause of action if they experience voter intimidation, obstruction, or a deception that interferes with their right to vote. And on this note, I don't want to take too much time, but I should thank in absentia Senator Sampson, because his comments, his feedback on the voter intimidation provision last session in committee were very helpful, and I understand in getting the new text to be stronger and to respond to his concerns. So those are some of the key things this bill includes.
Well, thank you very much for being with us and for your work on this bill and this issue. And thank you, Madam Chair.
Thank you.
Sorry, one more question. I'm not chairing. Thank you, Madam Chair.
Thank you, Representative. Are there any additional comments or questions? Representative Hoxha.
Thank you very much, Madam Chair. So go with your hypothetical example. What would be the remedy to that type of situation? Would it be just kind of unilateral authority from the state government to determine who the winners ought to be? Would there have to be a new election? And I haven't read the entirety of the bill. I will say that, and maybe it does, offer a remedy somewhere in the bill, but can you speak to that? What would be the remedy in that type of situation, and who would be the authority that gets to basically impose its will on the voters one way or the other?
Well, thank you very much for that question. I think that I have to say no respectfully to one of the questions you asked of whether this was going to be imposed on by state authority or overturning election. The remedy would be in a case like this. First of all, it's important to note that this is a case filed. This kind of case will be filed against the system of election, not against a particular election. If that makes sense, that distinction makes sense. So you'd say this system of election creates an unfairness, and it would create an unfairness in a future election. So you would bring that case in court, and the judge would look at the evidence, and if you prevail, if the evidence proves that your vote is being diluted, that your rights are being violated by this by this system in this case, because it's an at-large system, remedies could include districting, taking that at-large system and turning into a districted system in whole or in part, or they could also include things like alternative methods of election, things that in Alabama, for example, there's a good number of places that use a method known as cumulative voting as a remedy for Voting Rights Act violations. So that I hope that responds to your question. The key thing is that we're challenging the system of election, or perhaps the map. We're not looking at the results of the elections per se.
So the remedy would if there is one, if there is a remedy deemed valid by the courts, it would occur in a subsequent election cycle. It wouldn't be something that would be kind of imposed on the election outcome of said case that is being brought before the judge. Or is that also a possibility of altering the results of the of a particular election that is being contested in front of this judge?
Well,
through you, Madam Chair.
Thank you very much again for the question. I think that altering the results of an election is simply not an available remedy. But yeah, so it'd be the court must find that the remedy is feasible, and that might include, for example, if I were to file my lawsuit on election day and say I want the remedy today, the court might say, I'm sorry, Stephen, that remedy is just not feasible, right? So you want to file this case with some reasonable time to ensure that a remedy can be implemented.
Thank you, Madam Chair.
Thank you, Representative. For the second time, Representative Mastro Francesco.
Thank you, Madam Chair. I apologize. As the conversation continues, I start thinking of questions. Going back to the remedy, as Representative Hoxha said, so the court would determine that the process, we'll say, maybe needs to be changed going forward. You're saying it wouldn't change the outcome of that current election. Is that correct?
Yeah, if you're saying if in this hypothetical, the election has just happened, and then I file a suit saying, hey, this system of election is unfair, that would really be a prospective remedy. That is to say, for the future, the map or the system election might change going forward.
Okay, and then let's just say that the system, the process did change. Maybe they threw redistricting, and the same result happened. Then what?
Well, we'd need to know the facts of the case to really answer that question respectfully.
Well, my point is that when people vote, they vote for a particular candidate. And in this particular bill, it sounds like we are trying to pick a candidate or make sure that there's representation on any board or whatever based on race. Now, there are many towns in the state of Connecticut where maybe the population is maybe all mostly white, and they may have a candidate of a black and brown person that wins the election because they voted for them based on their qualities. The same thing with Bridgeport, Hartford, or New Haven. It's maybe made up of mostly the minority black or brown people, but the representatives of government are not, because they chose that person based on their qualities and not by race. So my concern with this bill is that we are trying to determine outcomes of a candidate based on race. And that is where I really struggle. And that's where I really have the problem with it. And so I was curious to listen to your remedy. If the court ordered that the process is not clear, we need to diversify. Maybe you need to redistrict that area. And at the end of the day, the same outcome, because people in that community, whether they're black, Chinese, or white, they like that candidate based on their qualities. And the same outcome happened, we'd be back to square one, right?
Well, I think that we're on the same page now. If the voters like that candidate, then that candidate is the voters' candidate of choice, and they're successfully electing their candidate of choice. So there would likely be no voting rights issue in that situation.
Correct, and that was the choice of the voters from day one. Doesn't
Right.
need to be challenged in court. That was their choice from day one.
I absolutely
Follow
agree.
me?
I don't think that case should, I don't think that case should come to court. If the voters are electing the person they want to elect, then that's a good thing. And that's not, that wouldn't be a voting rights problem. This bill would have nothing to say about that.
Okay, thank you so much for your testimony. Thank you, Madam Chair. I apologize for the second question.
Thank you, Representative. Seeing no further questions or comments from members of the committee, thank you again for your time and your testimony today.
Thank you.